Article 3, Section 15. The privilege of the writ of habeas shall not be suspended except in cases of invasion or rebellion when the public safety requires it. Ang habeas corpus ay nangangahulugang to have and ang corpus ay body. Kaya sa batas, ang habeas corpus ay nag-uutos sa pulis upang may pakita ang dahilan kung bakit na-detain ang tao. Pag naglabas ang korte ng writ of habeas corpus, ay inuutosan ito ang isang opisyal ng gobyerno na may kustodiya sa isang tao na dalhin ito sa korte upang tingnan kung legal o hindi ang pagkakadetain nito. Kapag illegal ang pagka-detain nito, kailangang pakawalan agad ang ikinulong at hindi maaring i-detain ng tao ng higit sa 3 araw kung hindi pa ito nasampahan ng kaso.
So, the privilege of writ of habeas, in other words, it is a safeguard against warrantless arrest and illegal detention. In the provision says, can only be suspended in cases of invasion or rebellion when public safety requires it. So, maso-suspend lang siya in case of invasion or rebellion. In addition, only the President has the power to suspend the writ or the privilege of the writ of habeas under the Article 7, Section 18. For example, noong balak sakupin ng Maute Group ang Marawi City, so President Rodrigo Duterte allowed warrantless arrest for those connected sa rebellion in Mindanao after he declared martial law only in Mindanao Group of Highlands for 60 days. And so the privilege of the writ of habeas is suspended in duration of the martial law.
Case example, John was charged with domestic abuse. Mary John's victims was too afraid to testify against him. During the hearing, the evidence presented was mainly hearsay testimony from a police officer that had spoken to Mary after the assault took place. A year after, John was convicted and sentenced to prison. The Supreme Court ruled in the case of Crawford v. Washington that hearsay statements of witnesses that refuse to testify in court are not admissible in a criminal case. John then filed a habeas corpus petition asking the court to overturn the conviction based on the Supreme Court decision.
Writ of habeas corpus, which literally means to produce the body, is a court demanding that a public officer deliver an imprisoned individual to the court and show a valid reason for that person detention. The procedure provides a means for the prison inmates or acting on their behalf to dispute the legal basis for confinement. The court holds the hearing on the matter during which the inmate and the government can both present evidence about whether there is a lawful basis for jailing that person. So, if you believe you are being detained unlawfully or without adequate evidence of guilt, you may consider petitioning for a writ of habeas corpus. You can appeal to the court throughout the writ of habeas corpus if there is unlawful detention, or you are kept for questioning without true evidence. You have the right for petition for just questioning.
Its purpose is to immediately release a person from unjust imprisonment or illegal restraint without sufficient cause. In habeas corpus, they must find out first the sufficient reason for a person to be in jail.
Section 18 of Article 3 of 1987 Philippine Constitution. No person shall be detained solely by reason of his political belief and aspiration. It is the right not to be detained by a reason of political belief and aspiration. The right guarantee the people to freely express their political belief and aspiration without fear of arrest or prosecution, which were denied during the time of President Marcos. Thousands of people who criticized the government, particularly the political opponent, were arrested. They were known as political prisoners. The new constitution makes sure not to repeat the history to this right were included. Second, no involuntary servitude in any form shall exist except as punishment for a crime whereof the party shall have been duly convicted. Right against involuntary servitude, it refers to compulsory, prohibits involuntary servitude. However, there are exceptions to prohibition. First, as to the punishment of a crime. Second, in the case of personal, military, or civil service in defense of the state. Third, in compliance to a return to work order issued by the Department of Labor and Employment. Fifth, Army and Naval enlistment. And the last, it is exercised by.
Ang section na ito sinasabi ang mga karapatan natin na hindi dapat ikulong ang sino mang tao dahil lamang sa kanyang paniniwala at hangaring pampolitika. Walang sino mang makukulong lamang sa kadahilanan ng kanyang pampolitikang paniniwala at adhikain. Ang tao ay may karapatang maipahayag ang kanyang adhikain sa publiko at hindi pwedeng maikulong sa kadahilanang ito, maliban na lang kung ang adhikain ay makakasira. Rule: freedom to believe is absolute but freedom to act in accordance with such political belief is limited. Rationale of the rule: every person has its own conscience, and this conscience, whether that of rich or poor, or that of weak or mighty, should not be restrained except when it was translated into action that directly transgress the law. Sinasabi din na hindi dapat pairalin ang anumang anyo ng sapilitang paglilingkod maliban kung ito ay isang uri ng parusa na katumbas ng isang pagkakasala. Ano nga ba ang involuntary servitude? Ang involuntary servitude is the condition where one is compelled by force, coercion, or imprisonment and against his will to labor for another, whether he is paid or not. It denotes a condition or enforced compulsory service of one to another, or condition of one who is compelled by force, coercion, or imprisonment and against his will to labor for another, whether he is paid or not. Exceptions to the prohibitions: first is punishment for a crime whereof one has been duly convicted. Second is service in defense of the state. Third is naval enlistment. Fourth is return to work order in industries affected by public interest. Last is exercised by parents and children.
Involuntary servitude, ang ibig sabihin nito ay condition when one is forced to work, o yung persang pinagtatrabaho ng isang tao na against his or her will, and whether she paid or not. Ang halimbawa nito ay yung mga ginagawang alipin ng mga natataas na tao, yung walang pakialam kung bigyan lang man sila ng sahod o hindi, dahil ito ay forced labor.
This is essentially embodied in the freedom of expression, but with emphasis on the provision against incarceration of political prisoners.
Hi, my name is JP Castillo. So for today, I'm going to give some of the facts from Bill of Rights of the 1987 Constitution, Section 18. So, first, what is the rule? Freedom to believe is absolute, but freedom to act in accordance in such political belief is limited. So, next, what is the rationale of the rule? Every person has its own conscience, and this conscience, whether that or a rich man or poor man, whether that person or if they are weak or mighty, should not be restrained upon when it is translated into the action that directly violated the law, or yung mga tao na gumawa ng isang bagay na ipapanish o vina-violate ng ating law. In the Article 3, Section 18, Paragraph 2, a person cannot be forced to render service against his or her will. Right to strike is encouraged under Section 8, but when there is letter to return to work, they should comply, otherwise they will lose their job. Why do we mean in involuntary servitude? It is condition where one forced to work to another against his or her will, or she or he is not paid or not. Yung pamimilit sa isang tao na magtrabaho at hindi nito binabayaran o nasweldohan. So, these provisions expressly denounce considered as slavery when involuntary servitude is permissible. Number 1, in the case of punishment for a crime committed. Next, if it is required to defend the state, it is under Article 2, Section 4. Next and last, when it is needed under that principle of posse comitatus, render assistance to render and maintain order.
Section 19. Excessive fine shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted, neither shall the death penalty be imposed unless for compelling reasons involving heinous crimes, the Congress hereafter prove it. Any death penalty already imposed shall be reduced to reclusion perpetua. Second, the employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by the law.
Ang seksyon na ito ay ipinapaliwanag na hindi dapat ipataw ang malabis na multa o sobrang multa para sa isang tao. This protect people from fines that is not appropriate to crime or violation they commit. Ang karapatang multa lamang ang dapat na maibigay at hindi lalabis ito sa kung anong nararapat na multa sa kanyang kasalanang nagawa. Gayun din ang pananakit ay hindi dapat ipataw at pati na rin ang hindi makataong pagpaparusa sa kahit anumang kamalian o krimen na nagawa.
Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provides for it. Ang parusang kamatayan ay hindi basta-basta hindi basta-bastang ipapataw, maliban lamang kung ito ay karumal-dumal na krimen na itatakda ng Kongreso. Any death penalty are already imposed shall be reduced to reclusion perpetua or known as life imprisonment o pagkakabilanggo habang buhay.
Ang pagpapahirap ng pisikal, psychological o ang hindi pagkilala sa kanilang mga karapatan o ang pagpaparusang nakakasira sa moral ng mga bilanggo o mga detainee ay lalampatan ng kaukulang batas.
I will discuss to you the Article 3, Section 20. The no person shall be imprisonment for debt or non-payment of a full tax. Sinasabi nitong section na ito na hindi dapat ibilanggo ang isang tao nang dahil sa pagkakautang o hindi pagbabayad ng sedula. So, here we can prove in this section that no one has been imprisoned because of borrowing a money or not paying a poll tax. So, utang lang tayo ng utang, guys. Charot.
So debt. So let's make it simple para mas madali natin siyang maintindihan. So babasahin ko muna siya bago ko i-explain ang salitang or ang meaning ng debt. So sabi dito, ang debt is fixed and a certain obligation to pay money or some other thing or things either in the present or in the future. So sa Tagalog pa, ang ibig sabihin ng debt is utang. So, ang utang ay state of owing something, especially kapag sinasabi natin debt, kadalasan nito ang involved is money. So, it is an obligation to pay. So, that which is due from one person to another, whether it is money, goods, or other valuable things. So, that which one person is bound to pay to another, either it is in the future or it's in the present or in the future. So, ibig sabihin lamang yan, kapag ang isang tao ay nagkautang, obligasyon na itong bayaran sa nakautangan niya. So, hindi lamang pera ang pwedeng utangin ng isang tao, pwede rin yung goods or other valuable things. So ulitin ko kapag ang isang tao ay nagkautang, obligasyon na itong bayaran sa nakautangan niya. It's either matagal na to or bago pa lamang. So that's it. Yun yung meaning ng, yun yung ibig sabihin ng debt.
Well, no person may be imprisoned for not payment of debt. An obligation of acquired through fraud may be criminally persecuted. In such case, the fraudulent act of securing the debt and not his default in paying it is punishable. The obligation arises from acts of ex delicto and therefore not considered a debt under the constitutional provision. So simply non-imprisonment or debt.
Poll tax. A poll tax, head tax, or capitation tax. It is a tax of a portion or magbahagi or magparte sa kanyang kinikita. A poll tax is a fixed amount for individual in accordance with the census, as opposed or kabaliktaran to a percentage of income. A poll tax, it is a specific sum levied or pinapataw upon a person belonging to a certain class without regard of property or occupation. A tax is not a debt. Hindi siya utang, since it is an obligation arising from law. Hence, its non-payment may be validity punished with imprisonment. Yung mga hindi nagbabayad, pwede silang makulong.
Section 21, Article 3 of 1987 Philippine Constitution, double jeopardy. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law
in an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Double jeopardy means when a person is charged with the offense and the case is terminated either by acquittal or conviction or in any other manner without the consent of the accused, the latter cannot again be charged with the same or identical offense. Ano nga ba ang ibig sabihin ng double jeopardy? Ang double jeopardy ay hindi mo dapat pwedeng kasuhan ng isang tao ng parehong o dalawang kaso. Ang double jeopardy ito ay isa sa mga basehan sa pagbasura ng kaso kapag ang akusado ay nauna ng napatunayang may sala or nakonvict na o napawalang sala or acquitted o ang kaso niya ay na-dismiss o tapos na. Ang halimbawa ng double jeopardy ay matapos ang trial ni A ay napawalang sala sa kasong pagnanakaw ng sapatos ni B. So si A ay hindi na pwedeng kasuhan ni B ng parehong pagnanakaw ng sapatos dahil during trial ay napatunayang walang sala si A.
Third, determination, dismissal, acquittal is made by court or competent jurisdiction. In here, there is what can be called double jeopardy if the sovereignty decides. Fourth, there is a second jeopardy. This means that there is a second risk that a person can commit like he did before. And last, the first and the second jeopardy pertain to the same offense, or one is necessarily included on the other one, or one necessarily includes the other. This means that if a person commits the same crime.
Examples of double jeopardy cases here in the Philippines is the case of Conrado Carmelo versus People of the Philippines and the Court of First Instance of Rizal, wherein petitioner Conrado Carmelo was charged in the Court of First Instance of Rizal on December 27, 1949 with frustrated homicide for having allegedly inflicted upon Benjamin Ovilo with a kitchen knife and with intent to kill several serious wounds on different parts of the body, requiring medical attendance for a period of more than 30 days and incapacitating him from performing habitual labor for the same period of time. On December 29, 1949, at 8 o'clock in the morning, the accused pled not guilty to the offense charge, and at 10:15 in the evening of the same day, Benjamin Ovilo died from his wounds. Evidence of death was available to the prosecution only on January 3, 1950, and on the following day, January 4, 1950, an amended information was filed charging the accused with consummated homicide. The accused filed a motion to quash the amended information alleging double jeopardy. Motion was denied by the respondent court. Hence, in the instance petition for prohibition to join the respondent court from further entertaining the amended information.
Good day everyone. Me and my group mates will going to discuss the Section 22, Article 3, 1987 Philippine Constitution, or also known as No Ex Post Facto Law or Bill of Attainder shall be enacted. So what is ex post facto law? Ex post facto law is a law that changes the legal status or consequences of an action after it has been already done, especially a law that makes an action illegal after it has been committed. So, ang ex post facto law ay hindi mo pwedeng parusahan ang isang taong nakagawa ng kasalanan nang hindi na isulat sa batas ang offense na kanyang nagawa.
So ex post facto law has a different characteristic. So ex post facto law means after the fact, meaning ang isang krimen or ang isang action ay nagiging isang krimen kung ito ay may nagbabawal or may batas. For example is the case of Onel de Guzman, which is the creator of I Love You virus, na kung saan hinuli siya for the crime of cybercrime. Kasi nga yung I Love You virus niya ay virus na nag-spread through computers through entire the world. So hinuli siya. Then sinampahan siya ng ng cybercrime, but then on that day na nahuli siya, wala tayong cybercrime law, which makes the case dismissed and Onel de Guzman have been acquitted. Meaning, hindi na siya magiging covered, hindi na siya naging covered ng cybercrime kasi walang cybercrime noong kinumit niya yung krimen. So therefore, he is not liable for cybercrime. So na-acquit siya. And with that incident, gumawa ang ating Congress ng cybercrime law. Kaya tayo ngayon may cybercrime law. And second, sa ex post facto law aggravates a crime or makes a greater when it was committed, changes the punishment and inflict a greater punishment that the law annexed to the crime when it was committed. Meaning, mas pinagrabe ang isang krimen at tinaasan pa ang penalty. Na kung saan, if you have been committed a crime and it was classified as petty or light offense lamang, pero dahil sa ex post facto law, which made applicable retroactively, naging correctional penalty na siya. And that is a prejudicial to the accused at bawal po yun dahil sabi po ng constitution, ng ating constitution. And last, the ex post facto law alters the legal rules and evidence or receive or different testimony than the law required the time to commission of the offense in order to convict the defendant. Ex post facto rin po daw ang isang batas kung binago ng manner of admissibility ng ebidensya sa isang proceeding. Bale, on trial na ang isang akusado and may batas na ipinatupad ang Kongreso at sinabi na bago na po ang rules of procedure. So, bawal po yun. So, ang ex post facto law, it is retroactive. And pinagpabawal sa ating pamahalaan ang retroactive. But there's an exemption with ex post facto law, which is if the law is favorable to the accused, meaning kung ang isang batas ay binago ang isang batas at ito ay itong batas na to ay magsisilbing favor sa penalty sa isang accused, therefore it will be applied for them. For example, you have been convicted with malversation for being a government employee, of course, and then you malverise a 11,000 and nasentensyahan ka ng prison mayor in its medium and maximum period. If the amount involved is more than 6,000 but not less than 12,000. So, na-convict ka na. So, you apply for a appeal. And then, the Congress pass a law which has been decrease the penalty or the penalty of the malversation and or adjusted the description. So under 10591 RA 10591, malversation, if you have been malversed 40,000 below, then you are going to render a sentence of 2 years. So ang malversation in public fund was reduced by the Republic Act 10591, which is penalized with 2 years and not less than 6 years. Kasi yung nasa Article 217 ng Revised Penal Code, sinasabi doon na 7 years to 11 years yung sentence. So through retroactive of the 10591, it will be going favorable to the accused. Therefore, it will be going to apply the sentence. So, marireduce yung i-render niyang sentence, and pwede siyang mag-apply ng probation because his sentence is not less than 6 years.
Applicability. The concept of ex post facto law applies only to the criminal and penal matters, not on law exerting civil rights and the like. So, ex post facto law applies only to the criminal and penal matter, not on civil rights. So, those ex post facto apply to the civil law. So, ex post facto law holding that the prohibition of retroactive law applies only to the criminal, not civil laws.
First thing, I will define you a bill of attainder. A bill of attainder is a legislative act which inflicts punishment without judicial trial, and its essence is the substitution of a legislative act for a judicial determination of guilt. It is contradicted to the Section 1 of Article 3 of Bill of Rights Section 1, which says that no one shall be deprived of property without the due process of law. Bill of attainder, it is not the due process. It's conviction of ginagawa mong criminal yung isang tao without the due process, at hindi yun pwede ayon sa Section 22 of Article 3 of the Bill of Rights. So, for example, you are a member of Association of Rebels, which is a NPA or the New People's Army. You are a member and you have been caught and apprehended. You are apprehended, but the thing is, hindi na or hindi ka maaakusahan or ma-plead guilty agad without the due process of the law. Means you must undergo to the due process of the law na matatrial ka muna para ma-convict ka at para ikaw ay maging isang criminal at tawagin kang isang convicted.